What happens when two companies decide to become one, but their legal risks, liabilities, and cultures don't align? That's where lawyers come in. In this lesson, you'll step into the role of legal counsel in a high-level corporate merger. You will advise on acquisitions, uncover liabilities, guide restructuring, and protect your client's interests, all while using persuasive legal English. Legal English can hold you back if you're working alone. Our school community gives you full access to lessons, live webinars, and real practice so you can speak and write more clearly and professionally. Join us today. The link's in the description. Today, we enter one of the most high-stakes conversations in business law, a legal consultation for a corporate merger. As counsel, your job is to analyze risks, identify obligations, and guide the deal safely to closing. You'll practice advanced legal vocabulary, persuasive grammar structures, and most importantly, how to sound professional and strategic under pressure. Let's begin by warming up your legal instincts. What comes to mind when you hear corporate merger? You might think of two CEOs shaking hands, but in reality, mergers are built on legal precision, financial clarity, and strategic risk management. Let's look at three key ideas. One legal risk in a merger is inheriting undisclosed debts or lawsuits from the acquired company. These liabilities could drastically affect the valuation or derail the deal completely. If hidden liabilities are discovered, then the buyer might renegotiate the price or even withdraw from the transaction. This is why legal due diligence is non-negotiable. Restructuring might be necessary when two companies have overlapping departments or conflicting management systems. Streamlining operations often requires tough decisions and strong legal guidance, and today we'll build the vocabulary, grammar, and legal instincts to manage exactly these situations. Let's begin with the core legal document of many mergers, the Share Purchase Agreement, or SPA. It's a binding contract that lays out exactly how shares will be transferred, how much is paid, what the timeline is, what guarantees are made, and what conditions must be met. The Share Purchase Agreement specified representations, warranties, and closing conditions. Each of those elements matters. Representations are factual claims about the company. Warranties are promises of accuracy, and closing conditions spell out what must happen before the deal becomes final. Imagine your client is buying 80% of a logistics company. The SPA guarantees that the company has no unresolved tax audits. If that turns out to be false, you'll need to invoke remedies and possibly halt the closing altogether. Contingent liability. In mergers, not all risks are visible. Some are contingent liabilities. These are possible obligations that may arise in the future, depending on events like court rulings, regulatory decisions, or unresolved claims. For example, the seller disclosed several contingent liabilities related to pending litigation. That means the company might owe money, but only if those lawsuits go against them. For example, you're advising a client acquiring a media startup. They're being sued for defamation, and while they deny the claim, if they lose, the damages could be huge. That's a contingent liability, and you must decide whether to demand indemnity, adjust the price, or delay closing until the case is resolved. Corporate governance. Let's look at the big picture now. With corporate governance, this term refers to how decisions are made inside a company, who has authority, what processes are followed, and how responsibilities are divided between shareholders, directors, and executives. For example, the merger raised concerns about corporate governance and board independence. In other words, will the new board protect shareholder interests or just follow the majority owner? Imagine this. Two mid-sized companies merge, and suddenly 5 out of 7 board members are from one side. Minority shareholders worry their voices and their dividends will be ignored. You, as legal counsel, are brought in to recommend protections like independent directors or voting rights agreements. Escrow arrangement. Now, let's talk about this. It's a tool that protects both parties in a high-value transaction. And an escrow, a trusted third party, often a bank or escrow agent, holds the purchase funds or key assets until all conditions of the deal are fulfilled. For example, the purchase funds were held in escrow pending regulatory approval. This ensures that no money changes hands until the seller meets obligations, like delivering financial statements or obtaining board approval. Picture this. You're advising a foreign client acquiring a biotech firm. The deal hinges on an antitrust clearance that might take weeks. To keep the deal moving, you recommend placing funds in escrow, showing good faith while keeping your client protected if the clearance falls through. Carve out. Sometimes a merger isn't about the whole company, it's about strategic parts. That's where the concept of carve out comes in. A carve out is when a parent company spins off or sells a particular business unit, separating it from the rest of the company. An example of this is the seller negotiated a carve out of its non-core manufacturing division. That means the company kept its main operations but sold a side business, often to raise capital or streamline focus. Imagine your client is acquiring a healthcare company but doesn't want its medical supply chain operations. You negotiate a carve-out, removing that division from the deal, rewriting employee contracts, and reallocating debt, all while ensuring the core business remains intact. Material adverse change, or MAC. In volatile markets, buyers want protection, especially between signing and closing. That's where a material adverse change clause, or MAC clause, comes into play. This clause gives the buyer a right to terminate or renegotiate the deal if something seriously negative happens, like a lawsuit, loss of a major contract, or regulatory change. For example, the buyer invoked the MAC clause after a key product failed in testing. That failure may have wiped out the target's valuation, justifying a cancellation or price cut. Here's a scenario. Your client is acquiring a tech company. A week before closing, the target loses its only government contract, half its revenue gone. The MAC clause gives your client a way out, or leverage to revise the terms. Now let's test your precision with transaction terms. Imagine you're advising a European client who's purchasing 40% of a Costa Rican tech firm. Before the deal closes, both sides need to agree in writing on what is being sold, the timeline for transfer, and what promises the seller's making about the company's legal and financial health. You carefully draft a contract covering all of this: warranties about revenue, conditions for payment, and dispute resolution clauses. What's the legal term for this kind of share transfer contract? That's right, it's a share purchase agreement. It governs how equity changes hands in corporate transactions. Imagine you're reviewing the books of a logistics company your client wants to acquire. Everything looks clean until you notice a footnote in the audit report. It says the company is being investigated by customs authorities for misdeclared imports. If they lose, the fine could exceed $100,000, but that's still uncertain. You raise the issue with the seller and advise your client to build in financial protections. So, what's the term for a possible obligation that may arise depending on how things play out? That's a contingent liability. and spotting them early can save your client a serious financial hit. Now, let's say your client is acquiring a hotel chain. The target owns several properties, including 3 restaurants, but your client doesn't want to manage restaurants. So, before closing, you help negotiate a side deal. The restaurants will be excluded from the main sale and spun off to a separate buyer. What's the term for this kind of deal where one part of the business is taken out or removed from the main transaction? It's called a carve-out. You separate non-core assets so the buyer gets exactly what they want and nothing they don't. Moving on to another one. Imagine your client is acquiring a software startup. Everything looks great until a data breach hits the news. Millions of users' personal data were exposed, and the company is now facing regulatory scrutiny. Your client calls you in a panic, asks, "Can we walk away from this deal?" Fortunately, you had negotiated a specific contract clause that gives them the right to terminate or renegotiate if any material adverse event occurs before closing. What's the name of this protective provision? That's the MAC clause, a tool buyers use to manage risk in fast-moving transactions. Picture this. You're advising an international investor who wants to acquire a construction firm. The deal includes transferring land titles, but some of the properties still show encumbrances. To move forward without exposing the buyer, you propose a mechanism. The funds are deposited with a neutral third party. The seller only gets paid once all encumbrances are cleared. What's this risk minimizing setup called? It's an escrow arrangement, a critical tool in deal security. In corporate law, especially during mergers, lawyers don't do everything themselves. They delegate, they coordinate, they arrange for things to be done professionally and correctly. That's where the passive causative structure becomes powerful. We use it when one party arranges for someone else to carry out an action. For example, we had the financial statements audited. The company didn't audit them directly, they hired experts to do it. Or the company got the contract reviewed by outside counsel. This shows legal diligence without implying the speaker did the review personally. They had the assets revalued before the merger. This phrasing makes it clear the action was arranged, not performed directly. This structure is highly useful when describing pre-closing steps, legal precautions, or expert involvement in a professional tone. You'll use it constantly in advisory conversations. Let's imagine you're walking your client through the final preparations before closing on an acquisition. You want to sound professional, thorough, and precise, and the passive causative helps you do that. Here's how you might describe each action. We had the financial statements audited by a Big Four firm to avoid any surprises. They got a formal tax opinion drafted to assess post-merger exposure. The company must have its intellectual property valued to finalize the purchase price. We had an environmental firm assess liabilities tied to the manufacturing site. Notice how these sentences show that the actions were arranged, not done personally, which mirrors how legal teams operate in the real world. This structure allows you to present complex, delegated processes with clarity and professionalism. In high-stakes corporate deals, how you deliver advice matters just as much as the content. You're not just giving answers, you're managing risk, offering options, and clarifying obligations. Modal verbs help you control the tone and legal force of your language. Let's walk through the most common modals in legal consultation. Should expresses a clear recommendation. For example, you should conduct a full IP audit before restructuring. This signals that the step is wise, but not mandatory. Might highlights potential risk. There might be regulatory delays, if we don't notify early. This softens the warning while still alerting the client. Could introduces options. We could structure the deal through a subsidiary. This keeps the door open for discussion, useful in early strategy meetings. Must signals legal necessity or strong action. You must notify shareholders under the bylaws. Here, you're drawing a line. The law or contract leaves no room for delay. Mastering these modal verbs lets you sound confident without being aggressive, professional without being vague. Let's practice some more. Let's look at 5 more modal verbs that appear constantly in contracts, negotiations, and professional legal advice. These are especially useful for formal writing and polished consultation. Shall is the classic contract modal. It expresses formal obligation. The lessee shall maintain the premises in good condition. This is common in agreements and has the weight of duty, but it's less common in modern spoken legal English. May signals permission or optional rights. The company may extend the deadline by mutual agreement. Here, may doesn't promise, it opens the door to possibility or discretion. Will shows legal consequence or expected outcome. Late delivery will result in penalties. This makes the consequence predictable and enforceable. Would often softens advice or introduces hypotheticals. We would recommend a phased acquisition plan. This is perfect for diplomacy, offering a viewpoint without sounding absolute. Can refers to legal ability or practical capacity. The buyer can cancel the agreement before funding. This might describe what the law allows or what is feasible in the situation. These modal verbs help lawyers speak with exact force, whether you're granting a right, outlining a consequence, or suggesting a strategy. Let's simulate a strategic meeting with a corporate client navigating a major restructuring. The client says, "We're considering restructuring our board and selling one of our divisions. What are our legal options?" This is where your language must reflect both clarity and nuance. The board may vote to restructure with a simple majority. Here, may gives them permission and highlights optionality. The contract will require notice before divestiture. With will, you're stating a future legal consequence, firm and predictable. We would recommend reviewing employee transfer liabilities. Would softens your tone, presenting this as careful advice rather than as a directive. You can terminate supplier agreements if they contain exit clauses. Can clarifies what's legally possible, not necessarily required. The company shall submit financial statements post-restructuring. Shall is formal and likely drawn from an agreement. You're referencing clear contractual obligations. This kind of language positions you as a precise, professional legal advisor, someone who offers clarity even in complex transitions. Now the best part, idioms. Kick the can. Let's start with a phrase often heard in boardrooms and legal consultations. Kick the can down the road. Imagine this. You're advising a company facing serious cash flow issues. They're considering a strategic restructuring, layoffs, asset sales, perhaps a merger down the line. But instead of acting now, the CEO suggests borrowing more or deferring payments to vendors. You pause. The financial pressure won't go away. It'll build, so you say. Delaying the restructuring plan would just kick the can down the road. This idiom means postponing a decision, not solving the problem, just pushing it into the future. In legal strategy, this can be risky. Waiting too long can limit options, increase liabilities, or expose the company to even greater legal consequences. Use this phrase when you need to push your client toward timely, proactive choices, not delay. Now, let's look at a phrase useful for lawyers managing sensitive negotiations or major business changes. Test the waters. Picture this. A client is thinking about selling off a division that hasn't performed well. The legal and strategic implications are huge. It involves employees, contracts, compliance filings. But jumping straight into action might spook or scare shareholders or trigger internal resistance. So instead, the company quietly speaks with a few strategic investors, gauges interest, and reviews informal feedback. You tell the client, before announcing the full divestment plan, the firm tested the waters with key investors. This idiom means trying something small, safe, and reversible to evaluate how people react before committing. In legal work, especially M&A or restructuring, testing the waters is often a smart move. It allows you to anticipate risk, fine-tune your position, or shift strategy before anything becomes legally binding. Now, let's consider a phrase you'll often hear during high-stakes negotiation. Take it off the table. Imagine this. Your client, a mid-sized tech firm, is negotiating to acquire a smaller competitor. After weeks of drafting and redefining the term sheet, your client proposes a favorable equity swap. But then the seller suddenly demands full cash payment, changing the nature of the deal. You advise your client carefully. At this point, we should take the original offer off the table. This idiom means formally withdrawing an option. It's no longer available, and the other party cannot rely on it. In legal negotiation, this can be strategic. Taking an offer off the table sends a clear message. Your client won't be pressured, and terms must remain within reason. It also gives your client more leverage, showing confidence, control, and the ability to walk away if needed. A ticking time bomb. So let's close this set with a vivid and serious phrase, a ticking time bomb. Picture this. You're representing a company preparing to merge with a logistics firm. Everything looks clean, the books, the structure, the assets. But when your team reviews the employee benefits contracts, you uncover a massive underfunded pension obligation buried in outdated agreements. You bring it to the client's attention and say, this unresolved pension fund issue is a ticking time bomb. This idiom refers to a risk that may not explode today, but it's quietly counting down. If ignored, it could cause financial, legal, or reputational damage later. In legal practice, ticking time bombs often hide in liabilities, compliance gaps, or outdated contracts. Identifying them early and framing them clearly is what gives you strategic credibility as counsel. Your job isn't just to fix legal issues, it's to spot the ones that haven't exploded yet. Let's bring everything together with one realistic scenario, something you could face in a real consultation. Your client, a regional software company, is finalizing a merger with a smaller AI firm. Due diligence has already been conducted, but you've just learned that the target company has a dormant business unit, one that was never dissolved properly. You explain calmly, this legacy unit could become a ticking time bomb. It's technically inactive, but if it's not restructured or shut down, future liabilities could arise. The CEO asks, can't we deal with that later? You reply, we shouldn't kick the can down the road. Let's address it now. Have the unit dissolved before the merger is finalized. You add, the restructuring plan should be approved by both boards, and a compliance audit must be commissioned immediately. Passive causative plus mobile verbs. Still unsure, the client asks if they can float an alternate deal structure. You say, sure. You could test the waters with an equity-based proposal. Just keep in mind, if their board resists, we may need to take the original offer off the table. In that brief interaction, you've shown leadership using strategic vocabulary, passive causatives, modal verbs for advice and obligation, and idioms that clarify risk and negotiation style. This is what legal English at an advanced level sounds like: clear, confident, and capable of guiding your client through complex decisions. So let's take a moment and reflect on what you've learned in this advanced simulation on corporate mergers. First, you strengthened your legal English vocabulary, words like governance risk and compliance audit that let you speak with precision about the legal and strategic challenges in high-value transactions. Second, we focused on grammar tools used by professionals. The passive causative helps you describe responsibility without pointing fingers. Modal verbs allows you to advise, suggest, and warn clearly and professionally. Third, you practice real communication, explaining risks, options, and obligations the way a corporate lawyer would during an actual merger briefing. And finally, you picked up idioms like kick the can down the road and test the waters, phrases that add color, clarity, and confidence to your legal advice. Do you want more real-world legal English practice? Join our school community for live sessions, expert feedback, and advanced legal English tools. The link is in the description. We'll see you there.